So he explained it much better. He's talking to the examiner, and I explained it from a legal point of view, and the examiner said, okay, I'm going to declare this novel over the prior art, and we had to then put it in writing, and we got it issued. In most cases, they'll say, oh yeah, I hear what you're saying. Put it down on paper, I have to do further searching, which is code for, okay, you probably have a pretty good argument, they're going to search it further because they think they can probably give you another rejection. So that's life, that's what continuations are for, that's what happens. But we hope to get it through, quicker because we want to bill our clients less and do an honest, good job, right? Okay, so do your homework. So your homework is the high-level analysis I talked about, the LCTA analysis I talked about, and be prepared with the claim amendment. They usually want it faxed to them ahead of time, sometimes emailed. Be prepared to explain the difference over the prior art. Know what you're talking about before you get on the call. It's basic. Know what you're talking about. Be prepared. Do your homework. And now we get to your response. All right, so your response. It's part 1. Cover sheet. Part 2, the amendments. Part 3, the arguments. Part 4, declarations. Sometimes you have test results to support it, which are probably better to be in your specification to begin with. Swearing behind the reference, that type of thing. So let's move on. Cover sheet. So you see on the slide labeled cover sheet, there's my file number. I blocked out some stuff. There's a serial number, the filing date, the art unit, the examiner. That's my block that I use. Most attorneys I found, they just have 2 columns. I found, hey, it's so easy to do this stuff on computers. Let's make it nicer to read and more presentable. Presentation is big. I got that from an immigration attorney, actually. He said, when we're dealing with an immigration issue, he said, which unfortunately I learned too much about, he said, here, take all your stuff, put it in a nice binder where you see through pages, have it in order to show it to them one after the other. Same type of idea. Make it nice, make it pretty. Use nice fonts and so forth. Steve Jobs type of thing. State what it is, state what each item starts on. Now, that's not to exclude having substantive arguments. I think it should be clear by now. I'm all about having substantive, real good arguments. That's what you're really going to win on. So, response to the office action of blah, blah, blah. Interview summary begins on this page, amendment begins on that page, remarks begin on that page. Next slide. Interview summary. Examiner will provide one. It's a good idea to state politely what was discussed. It creates a paper record. So, interview summary, here's an examiner. The undersigned thanks Examiner Sotomayor for the telephone interview December 6, 2011 and appreciates examiner's extra efforts in contacting the undersigned despite technical problems at the USPTO. A lot of problems with the phone system that day. The claims amendments submitted herewith were submitted for consideration during the interview, and during the interview it was agreed by both parties that the amending claims overcome the objections made in the office action. And, said it very friendly and said, not accusatory. The examiner admitted they were wrong. Doesn't win in arguments with your wife. It won't win an argument in the office action either. All right. You find a diplomatic way to say you were wrong, but don't say it like that. Don't let them, let them think you're being nice about it because you're putting this on the record. And as my former boss told me, they don't need you for anything. They can keep rejecting and make your life hell. They can do that. They work for the government. So you want to be nice to them and get them on your side. All right. There's, again, different strategies. Personally, this is my strategy. I find it works. Amended claims. Use status identifiers. So I'm just getting the meat and potatoes. It should be basic for those of you who have do this every day. Original, currently amended, withdrawn, canceled, and underline new text, strike through, deleted. I'm just giving how you actually write your actual response. Next slide, remarks and arguments. State what the office action said succinctly. So here's an example. What's the rejection under? What's the allowance restriction? Claims 11 through 14 have been rejected under 102B as being anticipated in the view of blah, blah, blah. Arguments are provided below to overcome the rejections. The office action is further restricted examination to claims 11 through 14. Applicant traverses this restriction, and maybe it could have said for reasons that are stated below also, or whatever, to be consistent. State what you're doing. Are you arguing amended? There's a perfect example. Next slide. Writing up a response to 102, 103 rejection. How are we doing on time? Okay, we're doing perfect. We've got 9 minutes, 4 slides or so. Writing up a response to 102, 103 rejection. And again, this is your last chance to send in questions. As soon as I'm done, we'll have a few minutes for questions. Writing up a response to 102, 103. So paragraph on your patent application, basically what I said you should write when you're doing your high-level analysis. Here it is. Start with your high-level analysis. Same thing. You're going to have your office action, high-level analysis, low-level analysis after that. I'm not sure every patent attorney does this. This is what I think every patent attorney that trained me had ever did. And it's a great idea because I can now explain it succinctly before getting all technical on the claims. Here's a paragraph on what claim 11 through 14 say. Here's a paragraph on what the citation says. Here's the citation, what they're about, what they talk about, what the difference is between this and that. Now that hopefully the examiner has read that and understands the difference, he can then go into the claims and he'll have the same high-level picture as I do, that I have in my mind, that I'm going to transfer to him. And and then we can go into the claims. I conduct examiner interviews the same way. Let's start at the high level. What are we talking about? Let's break it down. This is what this application talks about succinctly. Take the emotion out of it. Here's 50-page thing. This is what it's talking about. I can sum it down for you, or the relevant parts, as best I can. Here's what this one is talking about. Now we can get into the nitty-gritty once we've done that, into the component parts. State the law. Actually, before we get to component parts, I apologize. 102 case with a legal test. There's an example. I'm not going to read it. That's a typical citation I might use to 102 with the legal test, and I might highlight certain things if the office action is not proper, but state it. Don't assume examiners know it. If they're new, if they're whatever, they don't always know it. They have something like, I think, an 8-hour training before they start responding. It's true that there's a supervisor over them in the beginning, but they're not reading every word that they write. 103, there's an example you can use in your office actions, copy from the PowerPoint presentation with the legal test. Key to supporting it is articulated reason why it's obvious and so forth. All right, then what do? So, you use the LCTA for each claim limitation. So here's an example. I've broken it down, and I probably would actually use separate paragraphs for each of these things. So this is a real example. Limitation. Claim 11 of the present disclosure is directed towards a plurality of balls, with each ball having a, quote it, quote the limitation you're talking about. And in truth, if I could have avoided that whole preamble thing before I did the quote, I probably would have, but I felt it was better here to put it in. Generally spherical encasement with a hollow interior. So it's got the feature of generally spherical encasement with a hollow interior. So the office action states it's shown as follows, and this is actually a cut and paste from the response to the office action they actually drafted. So I cut and pasted. My kids like to say I'm going to win you at that, but I cut and pasted, whatever. I took it out of the office action, Porky Pig moment, and I put it into my response. Here's what you cited. Here's exactly what it is. I don't need to paraphrase. I don't need you to look over there again to see if I'm citing you accurately. Here's what you stated right there. Each ball comprises spherical encasement, blah, 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 in this paragraph and that paragraph and so forth. Now, I then did in my next paragraph the text and the analysis. As recited above I was referring to my high-level analysis that I talked about before, Figure 3 fails to show that the spherical encasement is hollow. Rather, the RFID tag appears to be held at a central plane, implying that the ball is solid. No text has been located within the written specification of Ito one way or the other. Ito's a prior art reference. And as such, the office action has not met the burden of showing that the prior art discloses each and every limitation of Claim 11. There it is. Further, as recited above, the balls are produced from translucent resin, so it is highly unlikely that these balls are produced hollow. And I went on, but therefore Claim 11 is allowable. There's the basic structure of the argument. Again, look at the slide. Here's the limitation. This is the exact limitation I'm talking about. And again, you need to decide each and every limitation. I cited that before, I cited that after, I cited the limitation. Here's what the citation, here's what's in the office action. I actually pasted it in. I think I'm the first one to do that. I don't know. Someone else has probably done it out there, but I think it's a great idea. Examiner doesn't have to flip through papers. He doesn't have to look back and forth and get confused, because this is very confusing. You're looking at a lot of references, a lot of papers. Put it all there. All he has to do is read through the office action. Make it easy, make it simple, make it sweet, make it nice. I think that some of those were synonyms. And then here's the text of the office, the text of the prior art. In this case, the text is the figure. I think I actually did put in Figure 3 in the office action. I'm pretty sure I did. I put in the picture of that ball, and then I put in my analysis. And once you're done with all that, we write our conclusion. So we have 3 minutes and no questions, so I will spend 3 minutes on the conclusion unless a question comes in. Please send me one. Conclusion. Please allow the claims. Simple as that. Withdrawal of all rejections and early acceptance of the claims is requested. We want to say, allow the claims, allow them in. All right, and then hopefully we'll get it allowed. All right, and we're up to the last slide, which says thank you. Questions, you can send them in right now, and I will hopefully answer them while I delay and think of something to talk about for the last few minutes. And you can reach me. My name is Michael J. Feigen, Esquire. There's my email, michael@patentlawny.com. My website, again, patentlawny.com. Phone number, and one of those fun legal disclaimers to not get sued. This presentation is meant to be a broad overview and a teaching aid. Do not construe this as legal advice that is contained in this presentation. All right, so for the next few minutes, why don't I go back and address this question again. So let's go back to the first one, and let me try and analyze this one again. I have found it convenient to define the article or as being inclusive. I guess he means inclusive, or as in it has to say both A and B in it. In the absence of definition, the courts have construed or as exclusive. So what I'm judging by context, exclusive, because the court cases have said you can't use or. So let's talk about claim language for a bit. Again, each and every feature has to be cited. So if you say a claim limitation is A or B, and one of them is cited, that's a problem. Your claim is not novel. If I say my invention has to have perpetual motion and nuclear warfare, and I say it has or, and the prior art shows Jess thermonuclear warhead in the War Games movie, then that's a proper citation. It says or. So you're saying inclusive, it has to say both. It has to have this or this. I don't know. I really have to disagree with the questioner. I don't think it's a good idea to do that. I think you might as well just use the word and. Why rewrite definitions when the Boolean word and is out there and it just follows logically? If I say it has to have thermonuclear warfare and it has to have world peace in it, or whatever I said, perpetual motion, it's got to have both. Cover it that way, write it that way. All right. And I guess the other thing to talk about is just that when you write the office action, just again, make sure that you're talking about the relevant points. Keep it concise, keep it to the point, keep it very formal, keep it very polite, and make sure to harp on the best arguments. You may even want to discuss claims out of order. And then when discussing dependent claims, generally what I think is done in the industry, not just me, is we'll say, Claim 2 is allowable due to its dependency on Claim, or the dependent claims are allowable due to their dependency on allowable Claim 1. The dependent claims are further allowable for the following reasons. Continue. Claim 2 is allowable for this reason. Claim 3 is allowable for that reason, and so forth. And keep doing the LCTA method on each and every dependent claim you have. And when you do that, you cover all your claims, you cover it systematically. That makes for a good argument. And preserve all your arguments. Don't traverse without rejections. Don't traverse without providing arguments against the rejections, is what I meant to say. Otherwise, you've lost it. It's the same thing as regular court. If you're going to argue new, if you're going to have a second response, and you have, you responded once already and you're responding again, I'd also like to incorporate all of the arguments I made previously. They still stand. In addition, this. So, for example, I might do that where I get a restriction requirement before the first office action, and the examiner maintains the restriction. So I want to keep I want to keep it. I want to say I maintain my arguments that I made there. Some cases I encourage the examiner to read them, and because he ignored them, and that's improper. That happens. And they might ignore arguments and say he has to respond to my arguments, and I preserve my arguments. And in addition, I make the following arguments anyway. Get it all down on the record. That's your chance to do it, and that's basically. In a nutshell, responding to an office action. Please contact me, patentlawny.com, ask me questions, and I enjoyed giving the presentation. It's a little different, not in front of a live audience, but I hope it's good, and I would be happy, again, to talk to anyone afterwards. Thank you for listening.